Hello, good citizens. My name is Dan. Welcome back. As you remember, in the last update, I got a letter in the mail from Gordon Comer, and then I gave him a phone call. And in that letter, he says he has dropped the charges that I'd laid against Arun Kundu-Thomsen, the watch commander at West Shore RCMP, who falsely arrested me in July 2018. And according to Gordon Comer, he used the information that I had laid, and he also used the West Shore RCMP investigatory file. You know, the statements that the 3 police officers that arrested me wrote. Haha. He also says that he used the Crown Council's CHA1 policy for charge assessment guidelines. And as you recall, I had said that he was actually supposed to use another policy before this called the PRI1 policy. That's the policy they use for private prosecutions, which this was. This was a private prosecution, and he never mentions it in his letter. So I called him up, called him out, and he pretty much immediately hung up, and that was that. So now you see what kind of a public servant Gord Comer is. So now we're going to go through those 2 policies that he was supposed to use, one of which he completely left out. And let's see how Gord Comer did. So we're going to start with the PRI1 policy, and that's the policy that Gordon Comer was supposed to start out with. So let's go down here to, here we go. And it says right here, generally, BC Prosecution Service policy does not permit a private prosecution to proceed. Wait a sec. Did you get that? Have you ever looked up the definition of the word generally? So generally, they just don't allow people to do this. Generally, this is a right that all Canadians have. It's a safeguard against government partiality. And generally, their policy doesn't allow it to happen, to proceed. And that couldn't be more true. Anyways, let's move on. So it says here, Crown Counsel will usually take conduct of the prosecution or direct a stay of proceedings after making the charge assessment decision. Yada, yada, yada. The rest of this page doesn't really apply. And on the next page here, down where it says, when Crown Counsel receives a private information, which they did, or notice of a process hearing, which they did, for a private prosecution under Section 507.1 of the Criminal Code, which they did, the following process should be followed. Crown Counsel should review the private information, which they did, and any other materials provided by the informant. And as you all know, there was no material that I could provide because it was all in the possession of the police. They seized it all for the purposes of criminally prosecuting me at a criminal trial. So I guess because I couldn't provide it, it was going to be up to the police to provide it so he could review that information. Next, it says, review any existing investigatory materials prepared by the police or other investigative agencies relevant to the counts in the private information. So, yeah, there was some investigatory materials that were actually seized by the police, all the video cameras and all the videos and any audio that accompanies those. Those are existing you know what I'm trying to say, materials that may not be prepared by the police, but shouldn't that be reviewed? So anyways, next one down here says, review any previous related legal actions, complaints, or other private information sworn or attempted to be sworn by the informant. Oh, well, this is neat. So what this says is that if this person has ever tried to lay criminal charges against the government before, or made any complaints, or tried to sue anyone from the government, make sure you review all of those and use those as a basis to dismiss or drop the charges that they're trying to lay against more government officials or legal actions or whatever. Wow. So that's part of what they use to decide whether or not they're going to drop the charges that you've laid against someone who's committed crimes against you and broke the law, the Criminal Code of Canada. That's what they're going to use to decide to drop the charges that you've laid. Wow. Let's move on. I love this one. Where appropriate. refer the information and other materials to the police or other investigative agency, and request that they consider conducting an investigation and preparing a report to Crown Counsel. So you see where it says, where appropriate, refer the information and other materials to the police? So if it's the police that are being criminally charged on the information, is it appropriate to refer that information back to those police at that police department, at that RCMP detachment, to investigate? No, that's why it says where appropriate. You remember on my phone call with Staff Sergeant Sandhu, and I was telling him, well, according to Crown Counsel policy, by you calling me, this is actually inappropriate? Ding! Here it is. Where appropriate. Let's move on. Once the relevant materials have been received and reviewed, Crown Counsel should determine whether the charge assessment standard in the policy, Charge Assessment Guidelines, CHA1, or, where appropriate, Charge Assessment Social Regulatory Offenses, CHA 1.2, has been met. So you see here, it's actually part of their policy to use this policy before the CHA 1 policy. Right? That's what it says. Once the relevant materials have been received, didn't happen, and reviewed, didn't happen, Crown Counsel should then use the CHA 1. But that didn't happen here. And the next part also seems to support that. It says here, prior to the completion of the charge assessment, Crown Counsel should consult with a regional Crown Counsel, director, or the respective deputy about whether the charge will be prosecuted by Crown Counsel or a stay of proceedings will be directed or otherwise. So, if Gordon Comer did that, he would have mentioned it in his letter, but there's no mention of that. So we can only assume that he didn't do that. And you might be shocked to hear this next part. I know this whole thing's been shocking, but here's even more shocking. Here's where we confirm it with case law. Listen to this. Crown Counsel may direct a stay of proceedings at any time after a private information has been sworn. So what that means is, when I walk into the court building and have my paperwork signed by, I swear it and sign it and a justice of the peace signs it, once that's been filed, our Canadian prosecutors, Crown Counsel, can stay the proceeding at any time now. So as I'm walking out the door, it's being put in a file folder and it's been put on a shelf, and they'll get a notification about it. And they can stay that proceeding anytime. And that's it. That's all they need to do to drop the charges against themselves or the police or anyone that they want. So there you go. They got case law that they can just drop their own charges against them as soon as the ink is dry. So the rest of this page kind of goes into what Crown Counsel should do if there's actually a process hearing scheduled and the matter is set to go before a judge. And on the next page here, this is great. Listen to this. If steps 1 through 3 set out above have not been completed prior to a scheduled process hearing, and the Crown Counsel's application for an adjournment of the process hearing has been dismissed, Crown Counsel should, so I won't get into that, but listen to this. What they're saying is, if for some reason we actually got a good judge here in Canada, and it didn't get dismissed before it even got before a judge, and this good judge actually dismissed Crown Counsel's application to have it adjourned, and the judge wants it to go ahead because the judge probably knows what's going on. Here's a policy of what we should do. And it's hilarious that they have this policy because it'll never get to this. They have the power to stay the charges that you've laid as soon as the ink's dried. So they here we go. They got this well, it'll never happen, but we better write a policy about it. So it looks like we actually have a policy about it, and it looks like people actually have the right to do this. Well, no, they don't. Not if they have the right to stay this as soon as the ink's dry. So anyways, I won't read this because it's just a bunch of nonsense that's just, supposed to, make it look like you have rights, but you don't. So let's move on to the next page. And the next page says Crown Counsel should consider whether the policy, standards of conduct, conflict of interest, and protection of confidential information, STA1, applies to the potential accused named in the private information. And in this case, it's a watch commander of the RCMP. Where appropriate, I love that. Regional Crown Counsel should consult with the Assistant Deputy Attorney General as to whether outside counsel or a special prosecutor should be retained to take conduct of the file. And it says here ad hoc Crown Counsel, and there's a policy for that, or a special prosecutor, and there's a policy for that. And it's my belief that because this information, the charges I laid to have Arun Kundu-Thomsen, a watch commander at the RCMP within the jurisdiction of this prosecutor's office, Crown Counsel, that this should not have been reviewed, and the charge assessment guidelines and all this stuff should not have been undertaken by Gordon Comer because he is Crown Counsel. He is from the BC Prosecution Service. This should have gone, because it's criminal charges laid against an RCMP watch commander, this should have gone to ad hoc counsel, the ADH1 policy, or a special prosecutor's SPE1. And that's when they hire basically a competent defense lawyer. And they take that person and put that person in the position of a Crown Counsel prosecutor. That's why it's called ad hoc Crown Counsel or special prosecutors. And that person should have reviewed the information in this file and done the charge approval assessment. That person should have done this. Crown Counsel never should have dipped into this at all. But here they are. They might as well. They got case law to drop the charges as soon as the ink's dry. So why bother following policy? And here is the CHA1 policy. And it starts off, says, the decision to start or continue a prosecution is one of the most important duties of Crown Counsel. The Crown Counsel Act authorizes Crown Counsel, under the direction of the Assistant Deputy Attorney General, to, quote, examine all relevant information and documents and, following the examination, to approve for prosecution any offense or offenses that he or she considers appropriate, unquote. In carrying out this function, Crown Counsel are constitutionally required to act independently of all partisan concerns and improper motives. The independence of Crown Counsel is confirmed by Section 5 of the Crown Counsel Act, which requires that any intervention by the Attorney General with respect to approval or conduct of a prosecution, quote, must be given in writing to the AGA, published in the Gazette, unquote. The independence of Crown Counsel must also be balanced with measures of accountability. Crown Counsel must review the available evidence and applicable law and exercise their discretion in accordance with published policies. Available evidence? You mean like 4 cameras and a cell phone? This ensures consistent and principled decision-making. The charge assessment function of Crown Counsel is also independent of the investigative responsibility of the police. Reasonable cooperation and effective communication between Crown Counsel and the police are essential to the proper administration of justice. Hey, gee, I wonder, would that include the evidence that's on 4 cameras and a cell phone? I'm just going to skip to the next page here. The discretionary decisions of Crown Counsel are entitled to reasonable deference and should not be overturned or second-guessed by other Crown Counsel, including regional Crown Counsel, directors, or their respective deputies, unless they are wrong in fact or law, unreasonable, or contrary to the public interest. On any review of a Crown Counsel's discretionary decision-making, a standard of reasonableness applies. As the necessary legal context for any charge assessment decision, Crown Counsel must consider the presumption of innocence, the prosecutor's burden of proof beyond a reasonable doubt, and the prosecutor's fundamental obligation as a Minister of Justice, unquote, and see justice done. In discharging the charge assessment function, Crown Counsel must independently, objectively, and fairly measure all of the available evidence against a 2-part test. 1. Whether there is a substantial likelihood of conviction, and, if so, whether the public interest requires a prosecution. This two-part test continues to apply throughout the prosecution. Evidentiary test, substantial likelihood of conviction. Subject only to the exception described below, the evidentiary test for charge approval is whether there is a substantial likelihood of conviction. The reference to, quote, likelihood, unquote, requires at a minimum that a conviction, according to law, is more likely than an acquittal. In this context, quote, substantial, unquote, refers to not only the probability of conviction, but also to the objective strength or solidity of the evidence. A substantial likelihood of conviction exists if Crown Counsel is satisfied there is a strong and solid case of substance to present to the court. Now, the rest of this just kind of goes into admissible evidence at trial, so I'm going to skip over that. But I want to get into this next page here where it goes into the public interest test. And this is very interesting. It says, if Crown Counsel is satisfied that the evidentiary test is met, Crown Counsel must then determine whether the public interest requires a prosecution. Prosecution of society is a paramount concern of the criminal justice system. Justice does not require that every provable offense must be prosecuted. The resources of the criminal justice system are not unlimited. If reasonable alternatives are available, they should be pursued. Prosecution should be reserved for cases requiring full force of the criminal justice system, with all its available sanctions. In assessing the public interest, Crown Counsel should take into account the particular circumstances of each case and the reasonable public safety concerns of the local community. Hard and fast rules cannot be imposed. Crown Counsel should consider and weigh the following factors to the extent they are relevant to any particular case. So number one here, I won't get into all of these. I'm just going to read a couple that apply to the charges that I laid. So the public interest factor that weigh in the favor of prosecution is the seriousness of the allegations, and I made some pretty serious allegations. And of course, a lot of these don't apply to me, but the third last one says the alleged offender's position of authority or trust in relation to the victim. So this is the police officer, a watch commander, somebody with a master's degree in terrorism and security studies. And the last one, evidence that the offense was motivated by bias. And I'll just leave it at that. Obviously, the rest of that doesn't apply to me. And skip over to the next page, and there's a good one here right in the middle. The presence of reasonable grounds for believing the offense is likely to be continued or repeated. I would think so. The offense occurs frequently in the location where it was committed. Could be. The offense is one that affects the integrity, safety, or security of the justice system or its participants. Whoa! The offense is a terrorism offense. The offense was committed for the benefit of, at the direction of, or in association with a criminal organization. Ooh. And I'm just going to skip to the next page. Number 2, public interest factors that weigh against prosecution. And a bunch of these don't apply, but the second last one, I'll read to you. It says, the offense was committed as a result of a genuine mistake or misunderstanding of fact. So Mr. Terrorism expert could not have been, the watch commander, the guy in charge, could not have made a mistake or a misunderstanding of fact, obviously. He knew what he was doing the entire time he was doing it. I'm going to skip to the next page and skip to the next page after that. And we come to the last one where it says the need to maintain public confidence in the administration of justice. Well, that one would definitely apply. And just going to skip to the next page here. Exceptional evidentiary test, reasonable prospect of conviction. In exceptional circumstances where the relevant public interest factors weigh so heavily in favor of a prosecution that it is necessary to resort to a lower charge assessment standard in order to maintain public confidence in the administration of criminal justice, a charge may still be approved even though the usual evidentiary test is not met. Crown Counsel must exercise particular caution in such cases because the nature or quality of the available evidence or the exceptional circumstances said to justify resorting to a lower charge assessment standard, for example, the gravity of the offense, the identity of the alleged offender, or the degree of public outrage about the offense, hint, hint, could materially increase the risk of a miscarriage of justice. Under such circumstances, the minimum evidentiary standard, which continues to apply throughout the prosecution, is whether there is a reasonable prospect of conviction. A reasonable prospect of conviction requires that more than just, quote, some evidence, unquote, on each essential element of the alleged offense, but it does not require that a conviction be more likely than a acquittal. The term, quote, reasonable, unquote, means on reason, rationale, objective, as opposed to subjective. Quote, prospect, unquote, is forward-looking. It involves the expectation of a certain outcome, informed by previous experience and common sense. A, quote, reasonable prospect of conviction, unquote, exists if Crown Counsel, informed of all the relevant facts, is satisfied there is a rational and realistic basis for obtaining a conviction according to law. So, very interesting policies. There's a little bit more to it than what I've read here, but I'll leave a link in the description if you want to check it out for yourself in its entirety. Both policies. Hey, you can check them out whenever you have time. So what do you think? How did Gord Comer do when he completely left out the PRI1, the private prosecutions policy. He didn't even review that at all, according to his own letter. And then he skipped right to the CHA1 policy, which we've just gone through. And how do you think he did? How do you think Gord Comer did? Let me know in the comment section below. And in the next video, I'm going to be calling back the staff sergeant at West Shore RCMP, Raj Sandhu, and ask him what's going on. Gord Comer drops the charges, and then you call me for an interview. So you're going to find out what's going on with that next week, next update. Thanks for watching. Thanks for your support. Stay tuned.